Well, Bill Duncan speaking here, and welcome to Module 8 on the subject of easements. Well, what are we talking about with an easement? I thought to start, you should get some conceptualization of what an ordinary easement looks like and what it does. What we have in this graphic is a right-of-way easement, and it shows you how it joins to the road and how it links up with what would otherwise be a landlocked piece of land. That's dwelling house 2. Now, the area of the right of way forms part of the title of dwelling house 1. So dwelling house 1 has fee simple title under Land Title Act, as has dwelling house 2. But dwelling house 1 has granted this limited right for the owners of dwelling house 2 to cross their land for the purposes of storage of their car in their garage. Now, you should keep this conceptual plan in your minds, because an easement really is the grant of a right for a limited purpose. We'll look more carefully at a definition in more detail shortly. But that's a very common easement. I would say that most easements are for this purpose, and some, in fact, where the right-of-way is, there may be pipes, there might be communications wires, etc., under the surface, which go from the road to the second dwelling house underneath the title to dwelling house 1. So they are in the main what easements are used for common purposes. Rights of way, wires, pipes, etc., to give services to another property which will, as I said, otherwise be landlocked. Now let's look more carefully at the definition of an easement. Now here I've divided it into 4 separate elements. As I said in relation to the earlier slide, it is a right over the land of another person granted for a specific purpose. And it becomes important to know what that specific purpose is. It isn't for any purpose, but it is for something that is some purpose which is stated in the easement grant itself. The person who gives the easement is the grantor, right? So the grantor in the diagram that we've got would be the owner of dwelling house 1. They are the servient tenant, and you will hear that phrase often in cases on this subject. The person who benefits from the easement, the grantee of the easement, would be, in the course of the diagram, the owner of dwelling house 2, is called the dominant tenant, because their rights override the servient tenant. An easement is an interest in land. It is a proprietary interest. Land can be transferred subject to an easement, and the person who takes the land, the transferee of the land, would have a right to use the easement. So it's not a personal right unless the document expressly says so, which it rarely would, if ever. And it will continue for the benefit of successors in title of the land benefited. And these, of course, are the dominant tenants, and they, in our diagram, would be the people who purchase dwelling house 2 from time to time. And the people who purchase dwelling house 1 would similarly be subject to the burden of the easement, which would remain regardless of the transaction. So the land burdened by the easement, the servient tenement, as I explained, remains with the grantor of the easement and subject to the rights of the grantee. Those rights are set out in the easement agreement itself. I have so far described the nature of an easement, but to determine whether one has an easement or not, there are further tests to apply. Obviously, there are other types of interests in land, like leases and profits apprend, which give third parties rights to use land. An easement is similarly an interest which gives a third party a right, a limited right, to use someone's land. However, for an easement to be formed, there must be certain elements. Normally, they are stated as being four major elements. Firstly, there must be a dominant and servient tenement. Now, I've mentioned what they are. The dominant tenant, as they're called, takes the benefit of the easement, and the servient tenant accepts the burden. The easement would be across the land of the servient tenant, and the dominant tenant would get the benefit of that particular right. If there's no dominant and servient tenement, then you really have no easement. And I make the exception only of the easement in gross, which I'll talk about in a minute. So, but the first element, you must find a dominant and a servient tenement. And normally the easement is annexed to the land of both those parties in some way. It either passes over them or passes adjacent to them. Secondly, the easement must accommodate the dominant tenement. Well, firstly, there is a sense that the easement must benefit the dominant tenement, but it also must leave some of the servient tenement available for normal use by the party burdened with the easement. If the easement, for example, purports to give exclusive use of the servient tenement to the dominant tenement, then it is not an easement right. An easement right is really a limited right. It limits the use to which the dominant tenant, the person taking the benefit, may make of the servient tenement. So if, for example, it goes beyond that particular degree, then it is said to lack proportionality, and too much of the servient tenement is affected by the easement. Now, if, for example, an easement purported to give the person taking the benefit the exclusive use of the whole of the servient tenement, you would be looking not at an easement, but at a lease, because that's what a lease does. So if the interest in land was done up as an easement instead of a lease, it would not be an effective easement and would be stricken from the register. The only thing I should mention in this is there are some interests which are statutory only, called easements in gross. They are not strictly attached to or used with other land. In other words, the dominant tenant in easements in gross does not have to own any land. I'll give you an example. Commonly in Queensland now, you have pipelines from oil fields to ports. These pipelines are protected by easements. They are a narrow strip of land upon which the pipeline is constructed, and they are protected by easements. Now, the owner of the pipeline does not own any land which is adjacent to or contiguous to the servient tenement over which the pipeline passes. Now, that is the one exception to the rule that there must be a dominant and servient tenement. In that case, the dominant tenant does not own land, but only owns the asset, i.e. the pipeline, over which the easement area is set. Now, there are exceptions in the Land Title Act like this in respect of public utility providers, which gives local authorities as owners of drainage, electricity providers, Telstra, and these types of people, they don't own land, but they simply own the assets going through the easements. That gives them what's called an easement in gross, and it may be on the same terms and conditions as to maintenance and repair and right of entry as an ordinary easement. We are mainly concerned with the situation where the dominant and servient tenements both own land which is either contiguous or in close proximity to the other land affected. Thirdly, the dominant and servient owners must be different persons, and there's a subject to the Land Title Act sections that I've set out there. Obviously, if the dominant tenant and the serving tenant are the same person, you don't need an easement because they own the land if there's some sort of unity of estate. So normally they are different persons and they have different rights. Some take the burden and those other person takes the benefit. Fourthly, the easement must be capable of forming the subject matter of a grant. Now, there are certain very common easements, rights of way which give access either by vehicle or by pedestrian access. There are common easements in relation to services, that's gas, electricity and drainage, sewerage, etc. at that point. There are easements in respect of negative easements in respect of the protection of one landowner to gain light into their property or the circulation of air. They're called easements for light and air, which is a negative easement preventing the adjoining owner from building a construction which might block out light or the circulation of air. But we'll come to that shortly. But some easements which have been created have been successfully attacked on the basis that the particular right that they give is not the proper subject matter of a grant, either because of the subject matter itself, and I've got some examples there. The right to protect a view is not traditionally the subject, cannot traditionally be the subject of an easement, or because, going back to the second principle rather, the easement does not accommodate the dominant tenement and simply overwhelms the servient tenement. Now, for example, the case of Ellenborough Park is often cited in this connection. I said earlier that an easement must accommodate the dominant tenement. That means that it must also benefit the dominant tenement and be connected with the enjoyment of it as a parcel of land. A mere personal privilege or commercial advantage intended to benefit the owner of the dominant tenement, but unconnected with the occupation of the land, is not an easement. In Ellenborough Park, the right of owners of houses near a park to use the park for recreation was challenged on the basis that it was not a recognised right that accommodated the houses. However, the court held otherwise, that it was sufficiently connected with the normal enjoyment of the houses as such to be recognised as a right which could be protected by easement. Now that simply meant that the landowners who had joined the park had the exclusive right to use that park, and that right was protected at law. The other thing coming out of this is that the dominant and servient tenements need not be contiguous or adjoining, although I've mentioned that that's the most common form of easement, but must be close enough to each other for the right claimed over the servient tenement to accommodate the dominant tenement in fact. So they must be close enough so that the benefit of the easement benefits the particular land which becomes the dominant tenement. Now the second case, Closs Farming Estates in Easton in New South Wales, was a case where the right to an easement was successfully challenged and the easement was removed from the title. In this case, a number of lots benefited one particular dominant tenement. So there was an easement rights in favour of one lot, got the benefit, and several lots bore the burden. Now the problem was that the particular servient tenements were to be used as vineyards, and the dominant tenant had the right to enter the servient tenement, harvest the grapes, and transport them away to be processed. Now, this right really affected the dominant tenements to a large extent. The court found that it was not a valid easement, apart from the fact that really it was not a traditional easement right, it was more like a profit up front. Now, profit up front is exactly that, where a third party is allowed on land to harvest or cut timber or such and such and remove it. It was more like that than a proper easement right. But even more than that, the rights of the dominant tenant were too extensive to be an easement. They really effectively sterilised the use of the servient land and made it almost impossible for the servient tenants to have any particular rights in the land itself, because the rights to the vineyards and to remove the grapes, etc., really overwhelmed totally the rights of the servient tenants. So really, when you look at it on the facts, in this case, you might well say that the rights of the persons getting the benefit of the easement, the dominant tenant, were almost exclusive to the, had exclusive possession, put another way, of the servient tenement to their exclusion. And that right was not an easement. I mean, really what should have happened, I suspect, is that it should have been a profit up front, or if they wanted exclusive use, exclusive possession of the vineyards, the dominant tenant should have leased the land in the servient tenement. So really, this concept really has two prongs. One, it must accommodate the dominant tenement, but secondly, it must be that type of right to form the subject matter of a grant. And if the right is too extensive, it will not be permitted to be protected by easement, and you'll have to think of some other form of protection. And I suggested perhaps if someone wanted exclusive possession, they should be taking a lease and not an easement. So cloth farming is an interesting case on both counts, and the easement was struck down in the courts as not being the proper way to protect the rights of the dominant tenant. So let's take this concept of an easement a little further. An easement is a recognised interest in land, but it's not an estate in land. I mean, the major estates, of course, are a fee simple and a life estate. But an easement, like a lease, creates an interest. It must be created in a certain way, that is, it must be created in writing to satisfy the statute of frauds requirements in sections 10, 11 and 59 of the Property Law Act. The writing must contain the material terms of the easement, and it must be signed by the party to be charged, that is the grantor. So if that exists, you would have an ordinary easement. If it was unregistered, it would be an equitable easement, and it would support a caveat. If you wanted to perfect the easement, you could specifically enforce that agreement. There's sufficient writing, providing there's consideration for the agreement, and the grantor would be forced to execute an easement in the appropriate form for registration in the titles office. So it creates an ordinary interest in land. It may be positive or negative. A positive easement gives someone a right to do something. In other words, it gives X a right to access Y's land. A negative easement, as I explained earlier, might be an easement of light or air. That is a restriction, a right not to have a neighbour construct a building close to the boundary, which might affect or obstruct light or obstruct the circulation of air. So easements come in different kinds. Of course, the most common is the positive easement, and they're the ones that you will see most of the time. I have mentioned earlier that an easement can only give limited rights to utilise the land burden. It can't take over the whole of the land. And as we saw, of course, in the graphic at the beginning of the podcast, the right to access only covered a small part of dwelling house number 1, which was the burden dwelling house. And of course, it was a right to go backwards and forwards with vehicles, which means it was temporary use of only part of the land. In the Queensland decision of Wagle and Toman, mentioned in the slide there, an easement conferred on a registered proprietor of the dominant tenement the right to have exclusive use of the larger of 2 garages for motor vehicles on the servient tenement. It was subject to the right of the registered proprietor of the servient tenement to have exclusive use of the other garage. Now, where you see the right to exclusive use, you immediately think of a lease. But the real question in relation to limited rights is really how much of the servient tenement does the easement occupy? Here, although it gave exclusive use to a garage, which would have meant a car would have been parked, it was only a small proportion in area of the servient tenement, which meant that from the point of view of proportionality, it was fitted in to accommodate the dominant tenement. In other words, if they had taken the whole of the servient land to park cars, it would have been too much to be an easement, and it would have been like the case of Kloss, which I mentioned earlier relating to the vineyard. So in Weigel and Thoman, there's quite a good discussion of proportionality by Justice Wilson in the Supreme Court. And this is quite an important factor when you're looking at the validity of an easement. And don't forget, how does it differ from another interest? I've mentioned a lease, which gives exclusive possession of the whole of land or part of land, as the case may be, and a profit apprend, which confers the right to take something from the land, that is timber or soil or gravel or something like that. But that right, the profit apprend, is simply one to right to enter someone's land for a specified purpose and remove a product. In an easement, of course, you're not removing any product of the land like soil, timber or gravel. So the interest in land which compare with it would be a lease and a profit apprend. I now want to look at how easements are created under the Land Title Act in Queensland. Easements, being interest in land, must be created in writing to satisfy the Statute of Frauds provisions. That is Section 10 and 11 of the Property Law Act and Section 59. In other words, there must be some written memorandum of the easement and it must be signed by the grantor. But of course, in Queensland, just about all easements to be enforceable must be in the appropriate form, properly signed under the Land Title Act provisions and registered following the registration of a plan of easement. And you should look in the Land Title Act to see the particular requirements for registration. It's almost true to say that there are really no implied easements in Queensland anymore. There's limited easements that might be implied by long user of the dominant tenement and easement area prior to 1st December 1975, and have a look at Section 198 capital A of the Property Law Act. But there are so few of these as really to be not worth speaking about. As we will see from later in the podcast, if you require an easement, and you haven't got a registered easement, or even one which is registrable and not registered, or even an informal easement, something in writing, signed by the party to be charged, which could be specifically enforceable to grant a proper easement, you would really have to go to the court and seek a statutory imposition of an easement under Section 180 of the Property Law Act. That's a position in Queensland now, and I'll talk about that a bit later. There are some statutory easements implied in the Body Corporate and Community Management Act in relation to services over lots. That would relate mainly to apartments and lots in those community title schemes. They are a specific exception. They are not registered easements as such. They are implied by statute and not by common law. In relation to registered easements, you can see whether a lot is benefited or burdened by an easement by searching the title, as the notation of particulars of easements must be on both the dominant and servient tenement titles, as would be a public utility easement in gross. You would see that from the titles. So I really won't say much more about implied easements from the point of view of practicality here in Queensland. The most common types of easements encountered, well, I've mentioned an easement of right of way and that is very, and probably the most common easement that is registered, and it gives the dominant tenement the right to traverse vehicles across the easement. It doesn't normally give the right to park. That would have to be specific, and it's not usually given. You can have an easement to park vehicles, as we saw in Wagle and Toman, and that's been confirmed in quite a landmark House of Lords decision, Moncrief and Jamieson, in 2007. There's quite a good discussion of that type of static right that allows the creation of an easement, and parking is a common example. An easement, a negative easement, not to obstruct light or air by construction or on contiguous land. They're reasonably common. They're not unknown in torrent system land. And another common one, particularly in this era of development of or refurbishment of buildings, an underpinning easement. And that would be a temporary easement, which would give a person a right, the dominant tenant, a right to put in underpinning infrastructure during construction of a building. So it's normally a temporary easement during the construction of a building. And of course the obligation not to withdraw support is a statutory one under section 179 of the Property Law Act. They are the main sorts of easements. The only others would be an easement for services, and that's to lay pipes under the ground or wires for Telstra or something like that, or electricity wires underground. And more recently in Queensland, of course, with the gas fields, there are easements in gross for pipelines, which I've mentioned earlier. So there aren't too many types of easements you have to worry about. We now should look at the extinguishment of an easement. We've looked at how they're created, and of course, because they can be created, they can be extinguished as well, and they may no longer be needed. There may be extinguishment by agreement, and that would involve the signature by the grantee, who's getting the benefit of the easement, and acceptance by the grantor, the servient tenant, who accepts the surrender, and the request to surrender on the appropriate form is lodged in the titles office, and the easement is removed from both the dominant and servient tenement titles. Now that happens from time to time. It can happen by merger of the estates and the grantor and the grantee. That means both the dominant and servient tenement come into one ownership. And of course, there's no point in having an easement. You can't give an easement to yourself, except in very limited early circumstances of development of the land. So by merger of the estates, the easement can be effectively extinguished. And the other one is by order of the court, section 181, on certain conditions, which are set out in the slide, and which we'll look at a bit more carefully in a minute. So under section 181, easements can be extinguished or modified. That is, the terms of the easement can be modified on certain conditions. But here we're mainly concerned with extinguishment, and I have to say that most of the cases in this area on section 181 of the Property Law Act deal with extinguishment. We now want to look at the reasons why a court may be persuaded to extinguish an easement, and when I say court I mean the Supreme Court only, subject to section 181 of the Property Law Act. Well, obviously there are a number of factors mentioned in the bullet points which a court might take into account, and primarily they could be summarised by saying that there is no further use for the easement, its continued existence might impede some user of the servient tenement in the future, or at the time of the application, for example. It might be wished to subdivide the serving tenement and the existence of the easement might be an obstruction to proper development. It may be that the easement is not used and it really has no practical or substantial value to the dominant tenant anymore, or in rare cases contrary to the public interest. And finally, there may be evidence that the dominant tenant has considered to have abandoned the easement or waived its benefit, either by words or conduct. So you should have a look at section 181, because it also refers to another factor, and that is that in these cases that money will be an adequate compensation for the loss or disadvantage that any person will suffer by extinguishment of the easement. The section also deals with modification of easements, but most of the cases are on extinguishment. And really, most of the cases that are successful where the easement is extinguished, often there's no need to pay compensation because there's really no loss or damage to the dominant tenant if some of these factors are proven. So let's have a look at some examples. In Rollwell, Australia, an easement of right-of-way had not been used for any purpose since 1964. That was some 35 years before the application was bought, and parts of it were covered in heavy vegetation with a deep storm water drain running it for its length. In other words, the easement was really not usable in the current form and hadn't been for some time. There was no real evidence why the easement was granted in the first place, except to give access to a water pump, which was no longer necessary, or hadn't been for the past 30 years, because of the advent of reticulated town water to the property. In such a case, the court found that the easement was obsolete and ordered that it be taken from the register, in other words, extinguished. In the other case, Averano and Mizzuzi, was a case where the court did not find that the application to remove succeeded. This was a case where the dominant and servient tenements were neighbours owning adjacent blocks of land, and they had easements running across each other's land in order to give right-of-way access to nearby streets. The particular driveway used by both of them ran down the middle of the two easements, so there were benefit and burden easements affecting both blocks in respect of each of the neighbours. One of the neighbours wished to place a fence down the middle of the driveway in order to fence their property boundary, and the other party sought an injunction to restrain the construction of this fence. The party wishing to fence then applied for the extinguishment of the easements over their land. Now, the court applied the tests in section 181 and found largely that it was a neighbourhood dispute. The court, particularly Mr. Justice Keane, found that there was no evidence to say that the object of the easement could still not be reached, or that the easement was obsolete. In other words, the court looked at the rights under the easement in relation to the current use of the land, and found that the case for extinguishment based upon these criteria was very flimsy indeed. The section was not meant to resolve merely neighbourhood disputes when the easement was perfectly usable and could still be used by one or other of the parties. Now, in Re-Eucalypt Group and Robin, an easement had been created in 1924. That was some 75 years before the application to the court, and it was an easement giving originally access to beachfront properties, which ran between the back fence of the beachfront properties and the beach itself. And of course, since 1924, as a result of the consequences of considerable erosion, 2/3 of the easement area was unusable, and certainly there was now other access to these properties, and it was not used for the purpose, it could not be used for the purpose for which it was formed, that is, a right of way for vehicles. However, the easement did have some value, and if you look at section 181(1)(b)(1), it says that one reason to extinguish an easement is that continued existence does not secure to persons entitled to the benefit of it any practical benefit of substantial value or utility or advantage. Well, in this case, interestingly, although it was of no use as a right of way because it was simply too small and dangerous, it was valuable because it did protect the view of the beachfront owners from being obstructed, that is, their view of the sea. Mr. Justice Ambrose, in this case, went beyond looking at the particular benefit conferred by being a right of way and took a wider view of the term any benefits of any practical or substantial value, and said that upon a proper construction of that section I just mentioned, the benefit of a right of way does not constitute the whole range of practical benefits of substantial value, utility and advantage, like the maintenance of a view, which is collateral or incidental to the continuation of the easement. So on that basis, Justice Ambrose refused to extinguish the easement because it still had some benefit to the dominant tenants. And finally, we look at this question of where the easement is considered to be abandoned. Now, abandonment of a property right, or the waiver of a benefit of property right, is very difficult to prove. The word abandonment is actually used in section 181(1)(c) as one of the factors which might be taken into account in whether a court would consider an easement extinguished. In Trewiki and 36 Wolseley Road, a High Court decision from New South Wales, an easement had been registered in 1927. At all times the easement, which was the right of way, had been impassable by reason of vertical rock faces, and since 1928 because of impenetrable bamboo. In 1956, the owner of the tenement installed a swimming pool across the right of way, and 2 years later erected a new fence across it. A chain wire fence had been erected in 1933 and renewed in 1967, and at no time had the dominant tenant used the entire right of way. Thus, in 1967, the owners of the Servian tenement said, well, this isn't being used, it's been abandoned, and therefore we would like an order that it be extinguished. The High Court said that mere non-user of the easement does not mean that it has been abandoned. Abandonment really means that acts or omissions by the person entitled to the easement. We've looked at how an easement might be extinguished. We now should look at how an easement might be created, not by the parties to the easement, but by the court. I invite you to read section 180 of the Property Law Act, which in general terms allows the Supreme Court to impose a statutory right of use under that section, which would lead inevitably, if successful, to the registration of an easement over the dominant, for the dominant tenement over the Servian tenement. Just as with section 181, the court would look at the criteria set out in section 180. Now, applications like this come about quite often because persons seeking the imposition of the right are effectively using the land without any easement rights at all. And the person over whose land they are traversing, if that's the case, or using, have in some way prevented them from further using it. And to do so, they would need to apply to the court to regularise the position. At that stage, regardless of how long they have used the land, the court will be forced to apply those particular criteria, and I've mentioned 4 of them there on the slide, the most important 4, to determine whether or not an easement will be imposed. Mere long use, as I've said previously, does not give right in Queensland to an implied right of easement. If you think you should have a right of easement or might be implied, you should really be applying to the court to have an easement imposed and registered. Well, what are these criteria, briefly? Firstly, being consistent with the public interest. This is not to show that it is in the public interest, merely that it is not inconsistent with that interest. In other words, it might be shown that it is not contrary to some planning scheme that the easement might be imposed. And of course, in later times, a court, when imposing an easement, may take into account certain aspects of that nature as planning laws have become more stringent. The imposition must be reasonably necessary in the interest of effective use in a reasonable manner of the land. Well, that is really interpreted reasonably strictly. To show this element, it does not have to be shown that there is no effective use to which the land could be put unless the easement was imposed, nor does it need to be shown that the owner of the land wishes to use the land in any particular way or for any particular purpose, and this use could not be effective without the advantage of the use of the land. it is merely reasonably necessary in the interests of one effective use in a reasonable manner of the land. But one doesn't have to show that the land is useless without the imposition of the easement. The question of the manner in which the easement is to be used on the land, the applicant seeking the imposition of the easement must come with a proposal to use the land in a particular manner so the court can judge whether or not it fits the criteria. For instance, in Gritner and Hadley, on the slide, the applicant sought to ask the court to impose a statutory easement for the purposes of utilising an adjoining servient tenement to enable vehicles to ingress and egress a proposed development of a warehouse for the purpose of parking and storage of vehicles. The adjoining potential servient tenement was used as a dance studio and by a number of children for that purpose. The owner of the servient tenement, together with many parents and children using the studio, objected upon safety grounds to the imposition of an easement for the ingress and egress of vehicles and for parking purposes. The court considered the plan and found that it indeed may be dangerous when taking into account the use of the servient tenement as it stood, as it may require cars to reverse and proceed forward and turn to make effective use of the parking area, and this could be a danger to children. Therefore, there was not sufficient evidence to justify the imposition of an easement, as it was not reasonably necessary for the effective use of the dominant tenement, as the parents of the children could park elsewhere in much more safety. With respect to whether or not the owner of the servient lands, burdened by the imposition, could be adequately compensated in money for the loss or disadvantage, this really refers to the drop in the value of the land burden. It is not calculated by taking into account what benefit the dominant tenement may receive, and to that extent, what uplift in value by the imposition of the easement the dominant tenement may obtain. So really, if it is possible to adequately compensate a potential servient tenant in money upon the imposition of the easement, a court will order that this be done, and it will simply be done on the loss of market value of the land burdened, without taking into account the benefit to the dominant tenant to give some sort of balance. And finally, the court is interested in negotiations for this. The court doesn't expect that the first time the potential servient tenant will hear about the potential imposition of a right of user is at the doors of court. These proceedings are often preceded by protracted negotiations, and the court can take into account the conduct of those negotiations to determine really whether a party has acted reasonably or not in making their refusal to grant the easement. For example, in Pacific Coast Investments and Cowlishaw, on the slide, the court did impose a statutory right of user in the form of a driveway to a car park, the imposition of which had already been accepted by the owner of the servient tenement at some time in the past. And there was adequate evidence that the servient tenant had previously acquiesced in the construction of the car park, which was linked by the driveway to be imposed to the road. So the situation there was that the owner of the burdened land had virtually already agreed to the imposition of an easement, but had changed their mind. So the judge found that at the time of the hearing, the continuing refusal was in all the circumstances unreasonable. But of course, there's another side to this coin. In Naylor and Pearce, on the slide, the refusal of a respondent to grant the access easement to the applicant for the passage of cattle after the expiry of a temporary access agreement was found to be reasonable in all the circumstances. The applicant had purchased with knowledge of the access difficulties and really had treated the respondent's land with complete disregard, enforcing their personal right to cross the land as they pleased. The offer of compensation by the applicant to the respondent was found to be nominal and trifling, and their assertion that they had a right to an easement was found by the court to be unreasonable, given their attitude to continuing to use the land, which was for the passage of cattle, given for a temporary purpose. They wish to continue it permanently without any easement. Thus, the court refused their application on the basis that their conduct in the circumstances was entirely unreasonable. So one can't say that in the normal course of events, simply because one has a right or has exercised a right, an informal right, to cross someone's land for some time, that they are automatically going to get the benefit of a court order to impose a statutory right of user. The court will still look at all the criteria and will look at the conduct of the parties to determine whether the refusal has been unreasonable or not. You should read some of these cases to get the flavour of the application of the section by the court. Now, that is all I wish to say about easements. If you read these cases and take into account what has been said, you will have sufficient knowledge to deal with it.